Elsewhere, the Independent Electoral and Boundaries Commission says it will also appeal a decision by the High Court that said it was not properly constituted, noting that there exists another ruling that is contrary of that view. This comes as ODM leader Raila Odinga's lawyer, Paul Mwangi, says he will file an appeal on Wednesday to challenge the High Court decision, including the verdict that President Uhuru Kenyatta was the promoter of the BBI bill. NTV senior political affairs reporter Kennedy Mureithi has those details.
For the better part of Monday, lawyer Paul Mwangi and a team of legal officers at his law firm sifted through thousands of documents he is putting together to aid in his case appealing a ruling by 5 High Court judges that put brakes on the BBI train. Mwangi says he has already put in an official notice to appeal the ruling.
We also have received a certified copy of the judgment that the court issued. We are waiting now to get certified copies of the proceedings of the court, and we are also waiting to get a copy of the decree. These are primary documents that you must take to the Court of Appeal when you are lodging your appeal.
Mwangi says one of the low-hanging fruits they will tackle is the evidence they have come across that President Uhuru Kenyatta was not the promoter of the BBI bill, arguing the judgment was fundamentally flawed.
As we are going through the documentation now for appeal, we have a letter here that was written by Chebukati himself when he was transmitting the bill to the speakers of the county assembly. And in his letter, Chebukati was very clear that he has received a draft bill to amend the constitution by popular initiative under Article 257. And he said that the said initiative is promoted by Honorable Dennis Owero and Juliet Mohammed.
The councils representing the state and Raila Odinga will be seeking to prove that the ruling by the 5-judge bench was more political than it relied on merit, insisting that the mistakes are too glaring.
One gets a feeling of a decision, people who had already decided what they want, and they are working their way backwards to justify a finding that they have already reached. Because if they were starting from the facts, then they would not get there.
The Attorney General's office is also putting together a petition to challenge the ruling through Solicitor General Kennedy Ogeto, who has already given a notice of appeal. Independent Electoral and Boundaries Commission Chairperson Wafula Chebukati, who was on a tour of Juja constituency to survey the preparedness for Tuesday's by-election, also says the commission is finalizing an appeal that will be lodged before the end of the week to challenge the ruling that indicated they were not properly constituted.
Sometimes in 2019, the High Court, presided over by Justice Okwanyi, made a determination that Article 250 of the Constitution is what applies to the Commission. Article 250 applies to all constitutional commissions and independent commissions, and it states clearly that you should have a minimum of 3 commissioners and a maximum of 9.
The IEBC position is that the ruling by the 5-judge bench does not hold any water.
What we are saying as a commission is that there are 2 conflicting judgments, and it's only a court of appeal which should be able to throw light as to which judgment in law should suffice for purpose of the commission.
Okay. Promoters of the BBI bill insist they are within the appropriate timelines and are also considering having the referendum alongside the 2022 elections. Kennedy Mureithi, NTV.